Hello guys, I am Nishtha Chukhanpuri and I welcome you back to my lecture series for labor law. In this lecture, we will be proceeding with definition clause and we will be dealing with section 2S, which deals with the definition of workman. So before we start with reading the definition of section 2S of workman, let us first analyze and let us get back to the object of the Industrial Dispute Act of 1947. So the object of the Industrial Dispute Act, as we all know, is that the Act aims to provide for mechanisms to resolve the dispute between the employer and workmen. Right. So we know what is industry now. Okay. So also we will be once I move ahead with the lectures, I will also be telling you what an industrial dispute actually is. But before we analyze the meaning of industrial dispute, let us first analyze the meaning of workman also, because an industrial dispute arises between employer and workman. Okay, so what is the workman actually that we need to ascertain to understand the industrial dispute also. Okay, so for understanding the definition of workmen given under section 2S of the Industrial Dispute Act. So as I've already told you that we need to understand the concept of workmen, because industrial dispute arise between an employer and a workman only, right? And Industrial Dispute Act, guys, for your kind of information, it is a piece of beneficial legislation. Okay, so the courts have enlarged the scope and applicability of this act, which is ID Act, and the judiciary has given very wide interpretation to the term workman. Okay, so I've already told you that section 2S of Industrial Dispute Act deals with the definition of workman. Okay, which reads as follows. So it says that, or it defines workman as any person, including an apprentice. Okay, so any person employed in any industry to do any manual, skilled, unskilled, technical, operational, clerical, or supervisory work. Okay, so any person who is employed in a particular industry, he will be workman if he is doing works like if he's doing work like any unskilled work or skilled work or technical work or operational work or clerical work or supervisory work, as the case may be. Okay, and so this is the first ingredient. Okay, the nature of the work has been defined. Then the section proceeds and says that such work which has to be which is being there, okay, that work will be done under the terms of employment, and such terms of employment can be either expressed or implied. And a workman will also include any such person who has been dismissed, discharged, or retrenched in connection with or as a consequence of the dispute. So this is why before taking up the definition of industrial dispute, I took up the definition of workman, because the definition says that workman will include any person, even if he has been dismissed or retrenched, or he has been discharged of his particular work. Then also that particular person will come under the ambit of workmen, because industrial dispute will still be there, right? If industrial dispute is carried on and a person is being into question, and that person is workman, that person is either retrenched or dismissed or discharged, whatever the case may be, in such cases again such person in question will also be included under the definition of workman. So that was my point before I took that is why I took the definition of workman before the definition of industrial dispute. Okay, so a simple reading of section 2S gives that section 2S defines workman as any person employed in any industry to do any manual, unskilled, skilled, technical, operational, clerical, or supervisory work for hire or purchase of rewards, for hire or rewards. Terms of employment can be expressed or implied and includes any such person who has been dismissed, discharged, or retrenched in connection with or as a consequence of the dispute. The first half of the definition says that a workman can be any person doing any nature of work. Second ingredient of the definition says that there must be contract of employment, and that contract of employment can be either expressed or implied. And the third ingredient of the definition of workman says that that a workman can include any person, okay, who has either been discharged or retrenched or dismissed when such industrial dispute has been pending, or in connection of a dispute which is being pending, and that person also, the person is in question, that person also will be included under the definition of a workman. Okay, now let's jump to the next part of the definition, which talks about certain exclusions from the definition of workman. So a simple read of the exclusions given in the section 2s simply means that so any person who is employed in army, navy, air force, police, they will not come under the ambit of workmen for the purpose of industrial dispute act. Firstly. Secondly, that any person who has been employed in any managerial or administrative or supervisory capacity, managerial, administrative, or supervisory capacity, such person will also not come under the ambit of workmen. And any person who is getting remuneration of more than rupees 6,500, that person will also not come under the ambit of the definition workmen given under section 2s of the Industrial Dispute Act of 1947. All right, so this is a simple definition which with huge amount of text which you can see in different books, like in the act and in different books which you must be referring. But a simple definition has simply 4 ingredients. The first ingredient of the definition given under section 2s of the workman says that workman is anyone who has been employed for any work which talks about any nature of work, which can be the skilled or unskilled, or so technical or operational or supervisory or things like that. Okay, so the first ingredient of the definition talks about the nature of the work. Then comes the second ingredient, which talks about the contract of employment. Okay, so there must be a contract of employment which can be either implied or expressed. The third ingredient says that a workman will also include any person who has been either retrenched or dismissed or discharged from his duties and in connection to any industrial dispute. Right. And then the fourth ingredient talks about the exclusions, that what all people will not come under the ambit of the definition workmen. So these people are nothing but okay, so these people are persons employed in navy, army, police, obviously. Then any person who is being appointed to do managerial, administrative or supervisory or managerial work, they will also not come under the ambit of workmen. And also any person who is drawing wages of more than rupees 6,500, they will also not come under the ambit of workmen for the purpose of Industrial Dispute Act. Okay, so I hope you have understood the mechanism, the definition provided under section by the legislature for the purpose of Industrial Dispute Act. All right, now let's look at some case laws which deals with, or which will give you a more clear picture of how courts have taken things into picture. Now this case is called a workman of Food Corporation of India versus Food Corporation of India. The citation of the case is 1985 second LLJ for Supreme Court. Okay, so the facts of the case are that there are 3 parties involved. One is the parent establishment, which is FCI, obviously. Then there is a contractor. Okay, and there are certain workmen who are there are certain employees of the workmen. Okay, I won't call them workmen because they will confuse you otherwise. So there are certain people, okay, which are appointed by the contractor to work in the FCI. So there are 3 parties: FCI, right, then the contractor, and the people who are being appointed to work in the establishment. Okay, so through contractor, these people are appointed, right? So the question came up, the question popped, whether the people who are working in the FCI, whether they are actually workmen for the purpose of Industrial Dispute Act. The court said no. Why? Because here the contract of employment is between the contractor and the people who are working, not between the parent company, which is FCI, and the people who are working there, right? Because they are being hired through a workman. They have procured through a channel. They have been procured through a channel, right? So therefore, the court said that these people will not come under the ambit of workmen for the purpose of Industrial Dispute Act for FCI. They are definitely workmen for the contractor, but these people under the meaning of section 2s of Industrial Dispute Act, these people are not workmen for the purpose of FCI under the Industrial Dispute Act of 1947. Clear? Then came the another case, which is called Punjab National Bank versus Ghulam Dastagir. Okay, the citation of the case is AIR 1978 SC 481. Now, the facts of the case are somewhat similar. Here, the bank, the Punjab National Bank, okay, the Punjab National Bank had an area manager, which, okay, and that area manager was given certain remuneration, certain compensation, certain allowances to keep the car, to keep the Jeep under maintenance. The Jeep was provided by the Punjab National Bank only. So got the case. So Punjab National Bank had provided a Jeep, the conveyance, to the area manager, and also the area manager used to get the allowances from the bank itself. Now what happened was the driver, okay, so for the purpose of maintaining the Jeep or the car, whatsoever he has got, for the purpose of maintenance of that, okay, he employed a driver under him. Okay, now, the question which arose was whether this particular driver, which has been appointed by the area manager, is coming under the ambit of workmen for the purpose of Industrial Dispute Act. The area manager contended that, okay, I have hired it, but you are giving the employment. Whatever allowances you are giving me, that allowances are only going to the driver. So driver will also be workman for the purpose of for the Punjab National Bank. The court said no. The contract of employment is between the area manager and the driver. The contract of employment is not between Punjab National Bank and the driver. Therefore, we cannot say that the workman is workman for the Punjab National Bank. It can be workman for, or it is employed by the by the area manager, so that the definition will not fit within the ambit for the Punjab National Bank. Okay, so let's summarize what workman is. Workman, first and foremost, there must be a contract of employment between the employer and the workman. Then the nature of work which is being described, that can be either technical or skilled or unskilled or operational, as the case may be. Then the third ingredient says that a workman can be also will be also any person who has been either retrenched or dismissed or discharged in connection to any dispute. So that person, if the dispute is pending, then again those person will be called the workman. And the last is the exclusion part, or the exclusions given from the definition, that certain people will definitely not come under the ambit of workmen, and these people are like any person who has been appointed as a police officer, navy officer, army officer, they will not be workmen. Secondly, if any person who has been appointed and that person is doing managerial supervisory work, then again those people, or administrative work, then again these people will not fit into the definition of workmen given under section 2s of the Industrial Dispute Act. And thirdly, if people are drawing the wages of more than rupees 6,500, then also these people will not fit under the ambit of the definition given under section 2s of the workmen. Simple, right? So with this, the definition of workman, I hope you are clear with it, you are thorough with it. You can read my notes also and you will have a clear picture. And just pause the video, clear your doubts. If you want to see the lecture once again, you can just rewind it. And now I will move ahead to the definition of industrial dispute. Okay. All right, guys. So now let's switch to another definition given under the definition clause of Industrial Dispute Act, which is Section 2K. And Section 2K, K is small k here, obviously. So Section 2K deals with the definition of industrial dispute. So before we study the definition of industrial dispute, let us first again jump to the preamble or the scope of the act we are studying. Now, again, the object of the act is, I hope it's thorough to you, it's by heart to you, that the scope of the act is to make the provisions for the investigation and settlement of the industrial disputes. Right. So, again, for the settlement and investigation of industrial disputes. So, this is, this is the only reason, the industrial disputes are the only reason by which industrial dispute act has its existence. So if there was no industrial dispute, the act would not have ever come into question, or it would have ever come into being, right? Because there were industrial disputes, and based on, because to investigate them, to settle them up, the act came into picture, right? So let us understand the meaning of what an industrial dispute actually is under the ambit of the Industrial Dispute Act of 1947. So section, to again repeat, the section, the relevant section for the definition is section 2K, K for kite, a K is small k, obviously, right? So let's read section 2K, or I would say let's just bifurcate section 2K. You can have a read from your barrack. I am hoping that you all are carrying barracks also while listening to my lectures. So just have a quick read from the barrack, and then I will give you the correct interpretation for how do we perceive the meaning of industrial disputes. So for after the plain reading of the section, you will you can crack the definition by three ingredients. Now, what are these three ingredients? The first ingredient, which tells you about the definition of industrial dispute, is that there should be a dispute or a difference, and that dispute or difference can be, or it can be either between employers and employers, or employers and workmen, or workmen and workmen. So the first ingredient just tells you that what are the parties to the industrial dispute. Now the parties to the industrial dispute are, number one, they can be either between employers and employers, or between employers and workmen, or between workmen and workmen. Very simple, logical also. Right. Now, the next ingredient for the definition is that the dispute can be either connected to. Now, what will be the subject matter basically? Now, the subject matter can be either related to employment or no employment. Now, what is no employment, or how can no employment factor be the question to understand the industrial dispute? That I will tell you in another 5 minutes. So, the first thing that you have to imbibe is that the industrial dispute can be either for the subject matter can be either employment or no employment, or either related to terms of employment, or either related to conditions of labor. Okay, so conditions of labor, you understand, right? If suppose I'm a workman in some industry, and being a female, I'm contending that there are no healthy sanitation facilities. That is a condition of labor. I am being employed there, so that's my right, that the employer has to give me perfect sanitization or uh, sanitation availabilities also, right? So that is conditions of labor. Proper lighting, proper sanitation facilities, proper water facilities, proper ventilation, all these things come under the conditions of labor. Okay, so if you are not being provided as a workman these conditions, then you can obviously contend for the industrial dispute, and in IDA would come into picture. The next thing is terms of employment. Now, what are terms of employment? Simple. I'm not getting my wages timely, or my wages are less, or my wages are being cut, right? There are so many deductions, etc., etc. So these are the second, the subject matter can be the terms of employment, right? Or my working hours are more, right? My workings are, if I'm overtiming, I'm not getting the proper wages, things like that. These will be terms of employment. The most, I wouldn't say the confusing, but I would say the most, the only tricky point, or which makes you think that what is no employment, right? So employment would be like, if I want to get employed, I'm not getting employed in the particular establishment or the industry on the grounds that people are saying, or the employer is saying. So for you are being employed, you are not getting employed, the terms of employment, right? What will be the no employment factor? Now, the no employment factor will be like, for example, I'm a workman and I am dismissed from my services. That is a no employment thing, right? So, on the subject matter of my dismissal, the dispute can evoke, and that dismissal is nothing but the no employment. Okay, or retrenchment. What is retrenchment? I'll tell you in the further lectures, guys. I just don't want to confuse you up, but just for for a casual understanding, retrenchment is something. For example, employer. For example, let's take this corona scenario. Uh, the particular industry, okay, the industrialist is not getting sufficient orders because there's a pandemic all around, right? They're not getting orders. So when they're not getting orders, they don't want to manufacture the product also, right? So in a day, for example, the manufacturer is having a plant which is capable of producing 100 units. Okay, but because of this corona, the demand is only for 50 units. So he has to cut short the supply by 50 units, right? Now, for cutting the supply by 50 units, okay, he will also have, because earlier the capacity to manufacture is 100 units. So in same proportion, he has also appointed similar number of workers. All right. So for example, but now when he wants to manufacture just 50 units, for these 50 units, the manufacturers, the workers he requires are more, right? He wants to employ them, but he has no choice. So the removal of extra workers, okay, the removal of extra workers will come into which is called the uh, is called retrenchment. Simple. When employer wants to employ, he says, I'm ready to employ, but I'm not having means to employ you. I'm not having sources to employ you. Where will I get my kharcha, deducted from? Where will you get that from? So that is retrenchment. Simple words. Okay? So this is retrenchment. So no employment scenario occurs when there is dismissal or discharge or retrenchment or termination and things like that. Okay. So these disputes also come into the perspective of industrial dispute. Last but not the least ingredient to understand whether any dispute becomes industrial dispute is that the subject matter which is in question. Okay, that subject matter should be substantive and direct enough to the participants of the industrial dispute. For example, I am a third party from the establishment. Workmen are contesting industrial relations. I bump into, and I say that I also want to be the part of industrial dispute. Who am I? I'm not a worker. I'm not a super. I'm not at any position. I'm not at managerial position. Who am I? Right. So the parties to the contract, the parties to the dispute. Okay. So all the parties to the dispute must be related to the substantive, either substantively or directly, must be related to the subject matter which is in question, which is being guaranteed, which is being assessed in the form of industrial dispute. Simple. Three ingredients. The parties who can be the parties to the dispute, they can be either employer and employer, they can be between workmen and workmen, or between employer and workmen. Second, what can be the subject matter? The subject matter can be either terms of employment or conditions of labor or employment and non-employment. Thirdly, that you know what the third ingredient says that whosoever are the participants, whatsoever is the subject matter, they must be in direct or in substantive relation to each other, and then only it becomes the industrial dispute. So the third ingredient, we can say, it's very common. uh, it's a commonly perceived legal angle which the court has given, which you can equate it to the to the intention. So it is a we can say it's a common legal language. Like if you are not a party to the dispute, if you do not have any direct or substantial interest, if you have nothing to do with this scenario which is in dispute, why are you calling it your industrial dispute? Okay, that's the point. Now the cases that I want to tell you for the purpose of section 2S is called Standard Vacuum Refining Company of India Limited versus their workmen. I repeat, Standard Vacuum Refining Company of India Limited versus their workmen. The citation is 1960 second Labor Law Journal 233. Okay. Now what happened here was, the situation is similar to the one we have read earlier, that there was a contractor, then there's an employer, then there are employees. Now, contractor basically employed the employees, and the establishment or the employer was not in direct contact with the employment between the employer and employee. He only gave an agreement that okay, to the contractor that you get me the workmen, I give you the uh, remuneration, and as the case may be, right? So the employment was done through the contractor. Now what happened here was, in this scenario, the employees who were working in that establishment, they came up with the demand that they want to end the contractual system, that contractor system, and they want to get appointed directly through the labor, through the employer. Getting my point? Employee said that they want to end the contractor system. That is, their employment was done through the contractor, right? They said, we don't want to be under contractor. We don't want any mediator. We want employers and employees to coordinate and to contact each other for the employment purpose. Simple. Okay. The Supreme Court held that this is very much an industrial dispute. Why? The question must have popped up in your mind also. We said workmen in the similar scenario in the earlier case, which was called in the earlier case like Punjab National Bank versus Dastagir case or FCI case. Remember, in the similar setup, we said that these people are not workmen for the establishment, but they are definitely workmen for the contractor. Remember. So in the similar setup now, how can you call it industrial dispute? Because these people are not workmen for the industry in question. The court said that okay, it's fine if they're not getting employed directly from the employer, they are into contractual system, but they are under the terms of employment, right? Whatsoever they are doing, that is because the employer, the main establishment, is saying so. Just by having a mediator, that doesn't mean that these people cannot raise any industrial dispute. The dispute will be industrial dispute, but these people are definitely not the workmen for the establishment. They are workmen only for the contractor. Got it? So these people, even when they are being employed, or they are under the industrial, they are under the contractual system of employment, wherein they are getting appointed for contractor through a third party. But that doesn't mean that have they cannot raise any dispute. They can still raise industrial dispute, and their dispute will be very much legal in nature, and which can be covered within the ambit of Industrial Dispute Act of 1947. Simple. Clear? I hope it is clear to you. All right, so let's jump to the another angle under industrial dispute, which is called individual dispute. Now, guys, the question that usually comes from this particular topic uh, goes like this: that when does an individual dispute becomes industrial dispute? Okay, so before I start with the legality of this topic, let's just get the normal idea of what an individual dispute would be like. So guys, for example, I am working as a workman and I am being terminated. Okay, so we know that when a worker is terminated, and if there is any dispute, then that particular worker will be called workman, right? That we have read in section 2S earlier, right? So when I am terminated, I am still the workman for that industry, right? I am being terminated. No one else is involved, right? So when no one else is involved, will it be called as industrial dispute? No, right? If we have a vague, how much ever understanding we have, we will say no, that won't be industrial dispute because uh, one person has been terminated and he's been terminated, and on I being terminated, why will uh, what other people will have access to, what other people will have to do with it? Because whenever we hear about industrial dispute, it is always about collective action, that there are so many people involved, there are trade unions involved, there are so many workers or employers and employment, that is being involved. Just single person, can he form industrial dispute? For non-labor law students, they will say no, obviously not. But from now on, we, the labor law students, will say that yes, even an individual dispute can become industrial dispute. How? Let's study that. So what happens is basically I am being terminated. Okay, Section 2A, A is your capital A. Okay, Section 2A was inserted after an amendment, and Section 2A basically says this, that if an individual dispute is just connected with termination, retrenchment, dismissal, or discharge. If a single individual is into question and the question he wants to raise, the dispute he has with the establishment is connected to four ingredients, which is discharge, termination, dismissal, and retrenchment. If the particular individual is having grievances with respect to four angles, then his individual dispute will be called as industrial dispute. Simple. So before we had this section 2A, it was very difficult for the workmen who were dismissed or discharged or terminated or retrenched to have a say in the establishment, because they've been terminated, right? Employer has said, okay, you are fired. They have no remedy. They can only go to courts. They can only knock the doors of conciliation or mediation or different mechanisms which are provided, but they don't have a stand. You know, the they already are workmen. We know the plight of the workmen in the Indian scenario. Still, and how will they have actually they how can they actually have their stand, right? So even when a trade union or collective workers or something, they are not they are not involved, because termination is the subject of single person, right? So if they are not involved, and still they can still that person can file for industrial dispute, and his dispute will be considered equivalent under the ambit of Industrial Dispute Act of 1947. Have you got it? So simply saying, an individual dispute does become industrial dispute when only four things or four issues are there with respect to the dispute in question, wherein a single individual is being involved. Now, these four angles are termination, discharge, dismissal, or retrenchment. If these four ingredients are there, or any of these four ingredients are there, I would say, to be more precise, that if any of these four ingredients from termination, discharge, dismissal, retrenchment are there, then only the individual dispute becomes the industrial dispute. Otherwise, this individual dispute will never be industrial dispute. Simple. Okay. So this was another extension to section 2K, which is called 2A. A is capital A here, and which talks about individual dispute becoming industrial dispute. Okay. So the another angle which I've already told you, that there is the angle of collective action, which is usually perceived to be like that whenever there is industrial dispute, there must be collective action. So you might find various content in various textbooks which talks about collective action. So don't panic. Collective action is nothing but simply saying that there are too many people involved, they are coming together and they are forming an they are behind a particular dispute, and they are contesting for their grievances before the uh, concerned managerial positions or the employers. Simple. Okay. So whenever you open your books and or whenever you open any online sources or whatever, and you just try reading industrial dispute, you will have three angles. The simple meaning of industrial dispute, which we have already done. Then comes the second angle of collective action, because industrial dispute is, industry is already so huge. The disputes must also be huge. So that is usually a collective action. And the third angle is individual disputes, which talks about that when does an individual dispute becomes industrial dispute. Okay. So the another thing which I want to highlight here is called the relation between the industrial dispute and individual dispute. I have already told you that individual dispute becomes industrial dispute only when there are four angles attached to it, right? So the Supreme Court has said that Section 2A, capital A, is an interpretation given to Section 2K. Keep in mind. Okay, so Section 2A is nothing but an interpretation which is being given in Section 2K, small k. Okay, so individual disputes become industrial disputes on four angles, and Section 2A, which deals with individual dispute, is nothing but an interpretation which is given to Section 2K, which is industrial dispute. Okay, clear? All right. So now I want to tell, now I want to discuss one very good case, I would say, which talks about industrial dispute per se. Now, this case is called Workmen of Indian Express Newspapers Limited versus Management of Indian Express Newspapers Limited. So I hope you must have heard about Indian Express, right? That's a very authentic, I would say, and the most reliable source of news these days. So this case, it came into question. It emerged in the 1970s. The citation is AIR 1970 SC 737. Okay. Now, the facts of the dispute are as follows. So, what happened here was there was a dispute which was happening within the Indian Express Newspapers Limited. Okay, so there was some dispute between the employers and the workmen there. So we have talked about collective action, right? So there is another name for collective action which is given a more statutory naming, which is called trade union. So we have Trade Unions Act in entirety in our syllabus. So that we will come to in the later lectures. But for now on, now you just remember this, that you will know what are trade unions, right? So these people, when they come together with the common agenda and everything, they form a trade union. Okay. So every establishment, guys, every establishment has its own recognized trade union. Okay. So what happened here was in the Indian Express Limited, Newspapers Limited, there was no trade union for the workmen. Okay, these journalists were not having their own trade union. But there was a trade union which is called Delhi Union of Journalists, okay, which was active. Okay, so uh, so you got the scenario. There is no trade union. The first scenario is of the entire climax of the picture. The entire picture is that there is no trade union for the Indian Express, but there is already a trade union of journalists which is called Delhi Union of Journalists, which is there to help the journalist out. So what happened here in the Indian Express Newspapers Limited, two workmen, there was a dispute related to two workmen. Okay, and these two workmen basically, because they didn't have any trade union, the dispute arose with respect to two workmen, and this was supported. This dispute was espoused basically by DUJ, which is Delhi Union of Journalists. Okay, so there is no union for Indian Express, but there's union at the another level, which is DUJ. Okay. Also, there was a point that 25% of the Indian Express workers, Indian Express journalists, they were the part of Delhi Union of Journalism. Okay, now the question came up, because it's an industrial dispute we're talking about, so we'll confine our understanding of the case to the industrial dispute only, right? So the question came up that, do you how come Delhi Union of Journalists is having representation in the industrial dispute related to Indian Express journalists? Getting my point? So Indian Express is not having any unions, but they are being, that particular dispute is being represented by the DUJ. And how come DUJ is coming into picture to support this particular industrial dispute uh, it, when DUJ is not directly involved? Okay, so the Supreme Court held that the Delhi Union for Journalists can have representation character among the Indian Express journalists, and it will definitely come under the ambit of industrial dispute. Simple. Got it? So even if a trade union is an outside organization which is supporting this particular dispute, it won't wave away, it won't fade away the character of industrial dispute just because another trade union which is not recognized by the establishment is involved, and they can have exactly substantial matter of interest in the dispute related to the Indian Express newspapers. Okay, I hope the case was simple for you guys. Anyways, the next thing that comes under section 2A, capital A, is the second clause which talks about the manner of settlement of individual dispute. Guys, so when we will study in the next lecture, we are going to study the manner of settlement of industrial dispute. In the same way, industrial disputes to an extent are being settled. So without having a knowledge of settlement of industrial disputes, we cannot understand the settlement mechanisms for the individual disputes. So in the next lecture, where I will be dealing with the settlement mechanisms of industrial dispute, there only I will take up section 2A clause 2, which talks about the procedure for settling the individual dispute. It's very simple. Okay, so for now, I guess this is more for the day. It's enough for the day. We have read the definition of workman, we have read the definition of industrial dispute, we have read the definition of individual dispute. Okay, just have a recap, just revise it up, open your books, open your refer my notes, refer any sources, and you I'm sure you will be thorough with these three topics. Okay, so stay tuned with the lectures. In the next lecture, we'll start with the authorities under the Act, which tells or which helps you to resolve the conflicts, which helps you to resolve the individual disputes, for which we have the entire Act into being, right? So all the best, and we'll see you in the next lecture. Take care.